Hello, YouTube. I'm Vince White. I'm an employment attorney, and I am answering publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question that was submitted via email. I'm going to strip out all potential identifying characteristics here. I don't want to out anybody, but I was told I could post this answer. Now I'll read the question into the record, and we'll go from there. I have a quick question you might be able to answer. If you have months of evidence and proof that you are being discriminated against on the basis of religious discrimination as well as retaliation, and additionally, an assault that was never fully investigated and the company agrees to settle, can the employee get more than the average $40,000 to $50,000 that most cases settle for, specifically because there are months of evidence from emails, team chat messages, and even fellow employees who said in chat, it seems they are biased against you. I mean, all good evidence. All good evidence case, not a he said, she said type. A case with good evidence, not a he said, she said type of case. Sorry, I was getting confused by the text. So, all right, there's two parts to a case. And we have a bunch of videos on the channel about how a case is valued. And I think you probably have seen those if you're sending me this question. But I will link a couple of those videos down below, just because they might be helpful. Now, the way these cases tend to be handled is in a bifurcated two-part system. The first part is, do you win or lose your case, right? So everybody's going to look at the case and everybody's going to decide, do we think this case would win if it went to trial? Yes or no. And it's never binary. It's never yes or no. It's always, they kind of do the thinking like, if we ran this case 10 times, does it win 8 times? Does it win 2 times? Does it win 50% of the time? And that's part of what people look at in settlement talks for a case. They're hedging for risk. They're trying to figure out how often they think this case wins if it goes to trial multiple times, because that gives them an idea of how much risk they're facing. The second part of the case is, what is the case worth? And that's going to be a damages calculation of economic damages, emotional damages, and potentially, because you have a retaliation claim here, potentially punitive damages as well. Now, you have lots of evidence, but it sounds like all of your evidence is tied to whether or not you are the victim of discrimination. And that's generally going to go to the first part, right? I guess over here, the first part. Are you going to potentially win your case? If you run this case 10 times, if you take it to trial 10 times, how often do you win? So you want to win. It's good to win. And if people believe you're going to win, you are going to obtain likely a higher settlement. That's all very positive. But it doesn't really go to the damages calculation. The damages calculation is tied to how much money did you lose as a result of what was done to you, right? The economic damages. How much trauma were you put through, right? What are the emotional damages? And yeah, if there's an assault that's tied to discrimination, that can definitely spike emotional damages. Other things that are going to be important to this, it's going to be how pervasive this was. Were they trying to isolate you? Are you treating with a mental health professional? What percentage of the time that you treat with your mental health professional are you talking about what happened at work? How much is it upsetting you, right? Do you have physical symptoms of trauma and stress? Physical symptoms of anxiety? Are you on medication for this? And all of that, emotional damages is a complex thing to calculate. But you have your economic, you have your emotional damages, and then the punitives are generally going to be very hard to capture in a settlement because nobody really knows what those are going to be. Because punitives are arrived at by going to a trial and having a judge or a jury say, I used my discretion to just give you this amount of punitive damages, right? So nobody really knows, nobody can calculate what that would be, so it's often really hard to capture emotional damages in a settlement negotiation. So you're asking me, should I get more than $40,000 to $50,000 that, a case might get? And $40,000 to $50,000 is not, that's kind of like if you're in an agency, none of that. I'm not sure that I think every case is different. I hate attaching the idea of an average value to a case because every case is different, right? So it sounds like your case, based on what you're telling me, has lots of evidence. And pause for a second. I believe everything you're saying, and I believe your case has lots of evidence, and it's going to be really easy to prove. I am taking everything you're saying at face value. This part is not for you because I believe you. Most people who come into my office and say, I've got so much evidence, don't. Why? Because they don't do this for a living. They're not stupid. They just don't do this for a living. And they don't really know what they need to prove their case, right? So a lot of people who come in like, I got the case for you. We're going to make millions. It's just like, yeah, bro, what do you think this shows and why? Like, I don't understand I don't even understand what you're trying to use this as evidence for, right? And again, not you. I believe you. Sounds like you have tons of evidence. Everything you're saying checks out. I'm just saying most people who think they have tons of evidence do not. Like, there's people who come in and like, listen, I got tons of evidence here. I got coworkers who are going to vouch for me that I'm a great person. Okay. What do you think that does for me? How does that show discrimination? Well, if I'm a great person and they're jerks to me, no, that doesn't show discrimination. It shows that different people think different ways about you. Now, if you can show me that some people think about you negatively because of your membership in a protected class, that's discrimination, right? So just quick caveat there. A lot of people are not great at evaluating their own evidence on their case. But it seems like here, based on what you're saying, you are, and I believe you. So assuming then that you have great evidence, because I believe you, the first part of the settlement, right, is in your favor. You're likely to win. And that means everyone, when they look at the case and they look at the risk here, they're going to say to themselves, if we run this case 10 times, he might win 7, 8, 9 times. He wins way more often than the average claimant would, right? So that's good. We don't have to hedge for risk quite as much when we're talking about the settlement. But we still have to do the second part. What's the case worth, right? Because if the case is worth, let's just say $100,000, and you win it 60% of the time, a lot of times you're looking at that and you're saying, well, maybe if I win 60% of the time and I get $100,000, maybe I should take $60,000 here because, if I win at trial, I could get $100,000, but I only have a 60% chance of winning at trial. Here, you might have an 80% chance of winning at trial. And we don't give out probabilities like this when we're talking to clients because it's unethical. But I'm trying to discuss, like, for your purposes, when you're evaluating, when you're sitting down and really doing an evaluation here of what you should and shouldn't be taking, you need to be honest with yourself and say, okay, I think I'm more likely than not to win this case. I think this case might be worth X amount of dollars. So then do that math, hedge for risk, and say, okay, well, listen, if the case is worth $100,000, just easy math, and if I win it 80% of the time, maybe I want to hold out for $80,000, right? If the case is worth $1 million and you win it 80% of the time, maybe you want to hold out for $800,000, right? And I'm not saying these are just big numbers, not even big numbers in the case of $100,000, that are easy for the math, right? It's just very clear to show that, like, okay, if the case is worth $1 million and you have an 80% chance of winning, maybe you do want to hold out for $800,000. Now, I guess that's not the most clear-cut answer. It's a little loosey-goosey. There's a lot of discretion and knowledge that goes into this. And judging from your email and my exchange with you, I think you're up to the task, right? It sounds like you're doing well. So I would apply this logic to an extent to your own little valuation there. And I'm not calling it little because it's small money. I'm calling it little because it's in your world, right? You're making the decision. What's your tolerance for risk? Do you want this case to go forward? Would you want this case to go to litigation in federal court where it's on a public docket? And I have no idea where your case is now, but I'm guessing it might be on a private docket if you're saying that you think cases go for 40, 50K. And could it be worth more in front of a jury? Maybe. Depends on the circumstances, right? There's a lot to that there. So I guess I'm gonna go back to your specific question. Could the case be worth more than $40,000 or $50,000? It absolutely could, right? When you go through this analysis, if everything is looking like it's in your favor, the damages calculation is high, if you believe you're more likely than not to win, all of these things can clue you in that your case could be worth more than that. There's a lot of cases worth less than that too, though, right? There's a lot of cases you look at it, you're just like, I think I win this case, but I think the damages are only 30 grand. I think the damages are only 20 grand, right? Those cases exist and they are common, right? There's a lot of cases, bad things were done, but the damages are low. I hate it. Frustrates the hell out of me because you want to put up big numbers for your client, but sometimes the damages just are what they are. Or sometimes the risk is what it is, right? If you can't put your client on the stand, that's a lot of risk. You might have a case that's worth $1 million, but if you think you lose 80% of the time, there's a good chance you're going to take 250K on that case, because secretly, you know, the minute your client gets on the stand, she or he's going to start saying wild stuff that's not going to help the case, right? And you just got to tell that client, listen, great case. You were wronged. I want to help. When we try to prep you to get on the stand, you become a new person and you behave like you hate yourself and you want to lose this case. Like, we have been at this for weeks trying to prep you, and it's not going to happen. Like, you should not go on the stand. That client will not like hearing that conversation, not one bit. And they will tell you you're wrong, right? And you're like, okay, all right. Well, why don't you talk about this with your friends and family and ask them if they think that you should testify. And if they have good friends and family, their friends and family are like, no, you should definitely not go on the stand. You are a loose cannon. Like, this is not, or just listen, you can't keep your story straight. Not because you're lying, just because you're under a lot of stress and a lot of anxiety, and being on the stand is really hard. And every time we put you on the stand, you're saying different things, right? And again, the person who's asking me this question, who I will not identify, none of these things apply to you. But these are all the logic that go into what settlement you might take or not take, right? Here, based on this email exchange with you, I think you'd probably make a great witness. You're really clearly communicating. Tremendous, right? So I hope this kind of rundown of the logic helps you in your decision-making process. If it doesn't, let me know and kind of be specific about where and how I fell short, and I'll try to make you another video that'll be more helpful. But when people come to me, and people call me all the time, like, oh, my attorney wants me to take X amount of dollars, what do you think? And I'm like, well, listen, I don't know your case the way your attorney knows your case. I'm working your case for 6 months, 8 months, 18 months, whatever it is. So I don't know the way your attorney knows, but if you want, I can give you the logic that you might want to apply to whether or not this is a good deal. And that's what I try to do, right? All right. If this was helpful, like and subscribe. Good luck out there. Get your money. And I will track the comments down below if there's follow-up on this. Take care.